New wholesalers often get confused between an assignment contract and a purchase contract. Now, these are two very different contracts, but you need to understand both if you want to wholesale a deal. And if you don't know the difference, then you are in trouble. But don't worry, because in today's video, I'm going to be walking you through the assignment contract line by line so that you are fully prepared for your first wholesale deal. And if you are new to the channel, my name's Justin You're I'm a real estate investor and entrepreneur here in Las Vegas. I've made hundreds of videos teaching people about real estate. And the goal of this channel is to help you grow your money and mindset. Also, if you want to see more personal content, follow me on Instagram at Justin You're Wrong. And before I get into it, let me just put a disclosure out there that this is not legal advice. I'm simply going to be explaining my experience with the assignment contract, how I use it, and just it's my experience. So I'm not an attorney. Don't take this as legal advice. And if you plan to use this exact contract that I'm going to be providing you, then make sure to have your attorney or your title company review it before you put it to use in your particular state, just to make sure that it fits with your state guidelines. Also, in this video, I am not going to be going over the purchase agreement contract. I made a separate video on that, and if you want to watch that video, go to the link in the description, watch that video, and then come back to this so you can fully understand the assignment contract. So what we are looking at right now is the assignment contract, and the exact name for this is the Assignment of Residential Real Estate Purchase and Sale Agreement, because we are assigning the RPA, also known as the Residential Real Estate Purchase and Sale Agreement. So the first thing that you have to know is these two things right here, the assignor and the assignee. So the assignor, that is you. That's the person who has the contract and is looking to assign it to someone else. So you are the assigner, so the wholesaler is the assigner, and then the assignee, that is the person who you are assigning it to. So it's the end buyer, whoever's purchasing this home. So let's get into the first clause. It reads, for the total purchase price of blank dollars, the undersigned assigner does hereby assign the assignee all rights, title, and interest to the residential real estate purchase and sale agreement for the real property located at blank. So to go over that real quickly, in this first section with the blank, that is when you are going to be entering the purchase price that the new buyer or the end buyer, also known as the assignee, what they are paying. So for example, if you have a home locked up under contract, meaning you wrote an offer to a seller, that seller accepted your offer, and now you are locked up. So you locked up the contract, you locked up the deal. That's kind of short term of what we say. But if you have a deal locked up at $100,000, so an accepted offer of $100,000, and you are looking to assign the deal to an end buyer to hopefully buy it for $120,000, you write the $120,000 in this line right here. So you don't write the $100,000 that you have it under contract for. You write what the end buyer is willing to pay for this. So you'd write it out in actual letters right here. So you would type out literally $120,000 right here in text form. And then here, you write it in the actual dollar form. So the actual numbers behind it, $120,000. And what this clause is basically saying is that you as the assignor are giving all of your rights, title, and interest to the actual purchase agreement, and you're handing it over to someone else, the assignee. That's what this is saying. So the next thing that you have to fill in is this line right here. So real property located at blank. So there you just write the property address for whatever home that you were assigning. The next line we look at is right here. Assignee shall deliver blank as an earnest money deposit to escrow. Now, if you do not know what an earnest money deposit is, an earnest money deposit is simply a good faith deposit that the buyer will submit as a good faith deposit for both the seller and for yourself as the wholesalers. So typically in my market, I'll usually ask the assignee to deposit a $2,500 earnest money deposit that's non-refundable. I know everyone will ask for something different. I know some people want to ask for $5,000, some people want $10,000 even. And so really the main purpose of the earnest money deposit is for you to make sure that the new buyer, the assignee, is going to actually follow through with what they're gonna say they're gonna do. So if someone says, yeah, I will buy that deal from you, but they never put an earnest money deposit down, then I don't wanna work with them because they don't seem like they're actually committed to buying the property. However, if I do ask them to put an earnest money deposit down of $2,500 and they do it by the date that we agree upon, then I know that they're at least committed and somewhat serious about buying the deal. So let's move on. If the earnest money deposit is not received by escrow by blank, this assignment of residential real estate purchase and sale agreement is void. So in this blank section right here, that is when you are going to be entering the date of when you should have the earnest money deposit delivered by the new assignee. So you wanna make sure that if someone's going to commit to buying a home from you and you're wholesaling it to them, you wanna make sure that they're trustworthy enough to at least put their earnest money deposit by a certain date that you both agree upon. And if they can't do at least that, then it might be an indicator that they're not a good buyer for you because they can't follow through with the simplest instructions. And if they do not send in their earnest money deposit on time by the agreed upon date, then this assignment of residential real estate purchase and sale agreement is void. And if you do not know what I mean by void, void means it's not legally binding anymore. So a normal contract that's signed by both parties, it's legally binding. So you are legally binded by that contract. When it is void, there's no more legal backing to it. So if they don't give in their earnest money deposit by that date, this assignment contract is void and it's not legally binded anymore. That's what that means. So the next line that we look at is right here. Assignee close of escrow date is on blank. This date supersedes the close of escrow date on the residential real estate purchase and sale agreement. So on this line right here that is blank, that is when you enter the date that the assignee or the end buyer is going to close on the home. And usually I will ask the assignee or the end buyer to close on the home before the actual closing date that's listed on the RPA or the purchase agreement. And the reason why I do that is because if by some reason, and this does happen, if the end buyer does not actually close on the home on time and the date of their closing date as the assignee and the date of the RPA were the same, if they were not able to close on time, then I might have to scramble for a new buyer or I might have to figure out how to buy it myself. And I wanna make sure that I give myself enough time to either find a new buyer or to get the funds to buy it myself. And so usually this assignee close of escrow date is sooner or earlier than the actual residential purchase agreement date. And that's the reason why I do it that way, is because I want to give myself more buffer time just in case the worst happens, which it often does. And then it's also specifically written out that the date that you list here supersedes or overpowers the close of escrow date on the RPA, also known as the purchase agreement. So if this assignee closing date right here is different than the closing date listed on the purchase agreement, then this is the one that supersedes. This is the one that wins because it says right here, this date supersedes the close of escrow date on the RPA. So next thing that we're gonna look at, I'll read this all for you just so you can understand. The assignee shall pay all escrow fees, HOA fees, loan policies, homeowner policies, and recording fees, and shall otherwise abide by the terms and conditions of the residential real estate purchase and sale agreement. So the first thing that's listed here is saying that the assignee or the end buyer shall pay all the escrow fees, all the extra fees that were agreed upon in the original purchase agreement. So it's saying anything that was originally agreed upon in the first purchase agreement, that's what the assignee or the end buyer is taking over. So they're gonna be taking over all the different fees that they have to pay that was agreed upon in the first purchase agreement. So that's what that's saying. Next thing, assignee may not terminate the residential real estate purchase and sale agreement for any reason. This is very good to have in your contract because it's saying that the end buyer cannot terminate the first and the original purchase agreement because they are simply taking over the contract. Doesn't mean that they can terminate the contract on their own doing. The next line says, assignee may not contact or otherwise disturb the tenants or occupants of the property before the close of escrow. So we are simply asking for the end buyer or the assignee to not disturb the tenants or whoever's living in the property, maybe squatters. The next thing that we look at is the default clause. So let's read this here. If assignee does not fund on the assignee close of escrow date, the assignment of residential real estate and purchase and sale agreement is void. So if the end buyer, AKA the assignee, if they do not fund, so if they are not able to actually perform and buy the property by the agreed upon assignee close of escrow date, then this assignment becomes void. This contract is void. It becomes no longer legally binding, meaning if you wanted, you could then go out and find another end buyer for it because this one is void. It's no longer working. Next thing that we read, the escrow company shall immediately release earnest money deposit to the assignor. That's you, the wholesaler. So if the assignee or the end buyer does not buy the home, they cannot perform, cannot bring the funds to the table, at closing, the escrow company is instructed to release the earnest money deposit that they give to you, the assignor or the wholesaler. So there's specific instructions for the escrow company to where the earnest money deposit goes in this specific scenario of the end buyer not being able to perform. The next thing reads, assignee shall be liable for all damages caused to the assigner. So technically and theoretically, as the assigner or the wholesaler, if the end buyer does not perform, this is saying that you do have the right to sue. That's theoretically, that's what it says. This is kind of like legal jargon and what this is for, but this clause shall apply unless A, assignee is unable to ensure title to the property, B, seller is unable to deliver clear title to the assignee, or C, seller fails to execute all documents necessary to a timely close escrow on the sale of the property. So what this clause is saying right here is that if the end buyer or the assignee cannot perform by the very end, then we as the wholesaler get to keep their earnest money deposit and we can potentially sue them unless these things are at play. Meaning, if the assignee or the end buyer cannot ensure title of the property, then they can keep their deposit and we cannot sue them. Or if the seller is unable to deliver clear title to the assignee, then they can keep their deposit and we can't sue them. And also, if the seller fails to execute all the documents, meaning if the seller fails to sign all the documents to make sure that escrow closes on time and the end buyer or the assignee ends up backing out, then they can back out, keep their deposit, and you can't sue them. So that's basically what that's saying in like the most simplest terms that I can think of. Next thing that we read, in the event of a dispute concerning the interpretation or enforcement of this assignment, the prevailing party shall recover their reasonable attorney's fees and costs. The assignment shall go into effect upon the signatures from the assignor and the assignee. So pretty much it's saying, if there's any drama and anyone gets into any arguments, that there's gonna be attorneys involved and whoever wins, they get their attorney fee and cost paid for. So it also says that if everyone agrees, this assignment goes into effect and is legally valid once both parties sign. So once the assignee or the end buyer signs, and once the assignor, also known as you, the wholesaler, once you sign. So that is the assignment contract outlined line by line so that you can fully understand it and be prepared for your first wholesale deal. And if you want to use this exact assignment contract, I've provided the link in the description below for you to download it for free. Also, if you want help to grow your real estate business, whether you are brand new or if you already have deals under your belt, DM me the word coach on Instagram at JustinYou'reWrong. Peace.